Good afternoon, colleagues. We are start our second part of our conference, international conference, and second part we will talk about human rights in digital age. And thank you for our next speaker, Dr. Larissa Zhdankina. She's also Ukrainian advocate, and she is Ukrainian, British, and now Canadian researcher and lecturer. And thankful for your participation. You make our conference not just international, also intercontinental. I know you're now in Toronto, Canada, with your lectures. You're a brilliant speaker and one of the best example of Ukrainian advocates who working in also as a researcher. Larissa, please be free with presentation and your speech. Thank you.
Thank you very much. Can you hear me?
Yeah,
okay.
Yeah.
Hi, everyone. It's absolutely wonderful to see everyone and to participate in such wonderful conference. It's my honor here. Thank you all so much for your invitation. And the topic of this conference, I think, is very, very actual for now, and all information will be very useful and informative for all of participants and for me as well. So the digital economy and digitalization of modern life are becoming a global reality. The task of digitalization is to create a digital space that will allow meeting the needs of society and in obtaining reliable information, developing infrastructure, creating information and telecommunication technologies, and as a result, the construction of a new technological base for the social and economic sphere. At the same time, the digital economy introduces social problems, acceleration of the pace of life, increase in the volume of the information, complications, social and economic conditions, constant emotional stress. In the sphere of society, new problems of the risks of unemployment, social stratification, the intensive implementation of the informalization leads to stressful situations and negative consequences for health of workers. Human beings and human rights are not only the epicenter of the human rights law and international humanitarian law, but also the basis for economic and technical progress in the world. The concept of human rights protection does not diminish over the years, regardless of the direction of modern, cutting-edge, and progressive research. The point in this case is not even the need to respect human rights and the desire to restore them, but rather the awareness for the very essence for human rights and their values. Digitalization can strengthen human rights and create challenges. On the positive side, it can facilitate successful information, communication, and education. However, there are the concerns about privacy, tracking, and potential misuse data. Striking a balance is critical for digital progress to respect and protect the basic human rights. The digital economy can affect the rule of law and principle of equality in various ways. Challenges include data privacy, cybersecurity, and the potential of digital monopolies. The balance between innovation and regulation is essential for upholding the rule of law and closing the digital divide and ensuring fair access to opportunity helps protect the principles of equality in the evolution of the digital economy. The digital economy can help restore human rights by increasing access to information, facilitating communication, and promoting transparency. Technological can be used to monitor and report to human rights abuses, mobilize communities, and create reform for marginalized voices. However, the fundamental goal is to bridge the digital divide, ensure privacy protection, and reduce the risk of surveillance in order to fully harness the potential of the digital economy to promote and restore human rights. Right to work in the digital age involves addressing issues such as automation, skill gaps, and job displacement. Ensuring access to digital skills training, facilitating adaptation, and fostering and enabling work environments are crucial for the people to navigate the changing work environment and realize their right to work. Policymakers have an important role to play in creating framework that balance technological progress with employment rights. The overlap between human rights law and digitalization creates both challenges and opportunities. In terms of challenges, we can say about privacy concerns. Digitalization often involves extensive data collection, raising concerns about the right to privacy and the protection of the personal information. The second one is the risk of surveillance. Widespread surveillance technologies may violate the right to be free from arbitrary interference with private life. Another one is a digital divide. Unequal access to digital technologies can exacerbate existing social and economic inequalities, affecting the right to education, information, and participation. It is recommended to stress on the opportunities. Access to information. Digitalization can improve access to information, promoting freedom of accession and right to know. Advocacy and mobilization. Technology can enable people to mobilize and defend their right, encouraging freedom, assembly, and association. Innovation for social goods. Digital technology can be used for humanitarian purpose, solving problems related to health, education, and social inclusion. Navigating this crossroad requires careful consideration of human rights principles when developing and implementing digital technologies, as well as a robust legal framework to protect people from potential abuses. The concept of human rights in the context of digitalization should be carefully approached to ensure that technological progress does not violate fundamental rights. Challenges include privacy violation through widespread data collection, surveillance, and potential misuse of technology. As I mentioned earlier, striking a balance between innovation and the protection of human rights is essential to ensure that digitalization does not undermine the principle underlying human rights. Regulatory frameworks and ethical consideration are critical to navigating this intersection. The integration of various forms of digitalization in the employer-employee relationship presents both dangers and advantages with regard to right to work. Regarding their dangers, the following aspect can be identified as key. Job displacement. Automation can lead to job displacement, especially in routine or repetitive tasks. Skills shortages. Workers may face challenges if their skills become outdated or irrelevant in a rapidly evolving digital environment. Inequality. There is a risk that certain groups may bear the brunt of job losses, reinforcing economic and social inequality. Although, along with this, we focus on the following advantages. Efficiency and productivity. Digitizing work process can improve efficiency by enabling streamlined process and increased productivity. New job opportunities. While some jobs may be automated, digitalization is also creating new roles in areas such as artificial intelligence development, maintenance, and ethical oversight. Enhanced security. Certain elements of digital advances, artificial intelligence, for instance, can be applied in dangerous environments, reducing the need for humans to perform dangerous tasks. Digitalization in human life makes it necessary to study the social consequences of digital transformation as digital technologies affect human life. The digital age and technology transform the labor market. The new changes, the new specialists should be digital staff. This means that they must be ready for change, continuous training, and meet the requirements of professional competencies and their continuous change. There is a need to master new professions and modernize old ones. Balancing this consideration is critical to ensure that the integration of digital advances respects the right to work and promotes a fair and exclusive labor market. Policy on retraining, education, and worker rights are essential to address these issues. And there is no need to look for what is the better, what is the more necessary in this world, fundamental rights or the opportunity to develop and protection of human rights. The scientific and technical progress for now and the latest digital technologies don't have the purpose of contradicting the principle declaring the human rights and human rights protection. All achievements in this sphere, in this area, should most likely serve not something impersonal, but they have to serve particular human rights and society in a whole. That's why I have repeatedly emphasized that there must be a balance between advantages and disadvantages, between human rights and new technology, especially digital technology. So, but I believe that the advantages actually outweigh the disadvantages. Thank you very much for your attention. As I mentioned earlier, I have absolutely an honor to be here with you. Thank you very much.
Thank you, Larissa, for brilliant speech.
I'm sorry, maybe there are some voices from here because I'm in London. There is only sunrise here in Toronto.
Super. Maybe you have some ideas about last GDPR bill in Ukraine, and we share your ideas to author Taras Rasenko, who's speaking just in first panel as a member of parliament and author of GDPR bill in Ukraine.
You know, maybe my topic is a bit theoretical, but it is the basis for form all of practical approach and mechanism how to better to apply the norm of Ukrainian law. But I think that we've got a lot of practice, a lot of grounds and experience, and we can get together every mechanism approach and create a very fundamental formula how better to restore human rights.
Please use your microphone. Sorry.
I'm sorry. Yeah, and I think that Ukraine is unique and a country, and we can to get together a lot of experiences, a lot of practice from different country, and particular from the different cases from outside, inside from Ukraine, and create our new formula how to better to apply the Ukrainian law, and in the same time maybe take a foreign experience how to better to restore the human rights in Ukraine. I think everything will be good, and Ukraine will win not only in the front line but in the sphere of adopting law. Thank you.
We will win. So, and thank you very much.
Thank you very much. I think you will have a very lively discussion, especially in the last panels. I've got this information. I think all participants will enjoy. Thank you very much.
Thank you. And we're very delighted to invite our next speaker, Dr. Anthony Evans, open banking and cybersecurity, international level expert. Thank you for your visit to us, and welcome to your lecture.
Thank you very much. Thank you for the opportunity. I'm in excellent company and feel somewhat humbled because I'm here, I think, to propose a few small ideas and see if I can learn and be supported in making some of the ideas useful to Ukraine in its current days. A little bit about myself. My background is in open banking, and I have supported open banking and open finance ecosystems for about 5 years or so now. I worked in the UK's open banking implementation entity. So I have a startup consultancy targeting open finance. I also have a startup targeting cybersecurity, which is supported by the UK government, which involves providing a great deal of immersive cybersecurity training. The reason for my involvement in Ukraine and support is because my ex-wife was British-born Ukrainian, and my children regard themselves therefore as Ukrainian, because that's much more interesting than being English. So I shall press on, I hope, if this will. Good. The idea that we have is to use our knowledge of open banking, API-based systems, which of course are spreading in popularity across the world, and build something rapidly in Ukraine, which we call OpenX, sometimes called Open Everything. It's building on the existing high degrees of technical expertise and environment within Ukraine, in particular looking at DIA. And our goal is to help generate immediate employment by creating a national training scheme in open technologies, and help establish Ukraine as a world center for this kind of technology and ultimately a hub for inward investment. Of course, cybersecurity is important anyway, but in particular these days in Ukraine. And so we're considering thoughts like schemes to train and assure cybersecurity, perhaps based on something like the DORA legislation currently being published in the EU, where ecosystems of participating organization collaborate in order to create the same level of cybersecurity across, say, the entire supply chain or something like that. Plus, of course, support offensive or defensive cyber expertise. Oops. Okay, I'm going to skip. Save you a little bit of time. I skipped accidentally a slide, but that's fine. I think it was to discuss why Ukraine is in a good position. We know this. The picture is to integrate, as I mentioned, open finance, OpenX, which can support a wide variety of technologies with existing and available technologies, perhaps extending the functionality that's already available, but also perhaps addressing some of the security issues that have been considered before, because the ecosystems here are all FAPI compliant, that's financial grade API, with very high levels of security. It could also open up innovation from certified third-party providers on an international basis. So the idea is to combine the two, build on the expertise that's already available. So we would like to investigate the possibility of including a wide range of services, not just finance or open banking, but agriculture, supply chains, sustainability. We've done some research in this already. Energy and insurance, they're already being tackled in Australia and Brazil. We can do the same. And health, for example, including mental welfare. Many more industries could be included within a broader ecosystem. The urgency is because we want to try and support Ukraine in accelerating progress despite the circumstances, and establish the grounds not just for immediate improvements, but longer-term recovery and establishing the Ukraine as a world center, as I say. So one of the reasons, of course, that this thing is complicated is because of regulations. These are regulations initially in open banking primary, then followed by secondary regulations that set out the detail, but it's multidisciplinary across many, many platforms. And this is complex, even in a single discipline. The challenge of doing it across multiple ministries and business sectors is significant. This is one of the reasons why I would dearly like the expertise. I am basically coming to you with simple ideas that need to be refined and adapted to do the right job for Ukraine. Your assistance in this would be very, very much appreciated. Cybersecurity, just a little bit about this. I'm very fortunate in representing a Brazilian-based organization that has what I would call a flight simulator for cybersecurity, which enables training and testing to be very, very much more realistic and immersive. We would like to have the opportunity to use this to support Ukraine, training individuals. It's been used a great deal for this in its native Brazil. We can see clients include the Brazilian Federation of Banks, Febraban, also the military and national critical infrastructure. It's used widely for technical training. There are already national industries, training schemes that use this capability, and also wargaming and events called CTF, Capture the Flag, which this tool is used at the basis of some of the largest exercises in the Southern Hemisphere. It's equivalent, for anyone that's aware of it, to the Estonian platform called CR14, which is used by NATO. So the challenges. I am only a small consultancy. People very sensibly talk to the large organizations because they're able to bring much more power, hopefully, and change. Hopefully, the ideas that we can present are valuable for Ukraine. I can only do this and do the right things with partnerships, advice, and guidance. Hence my comment at the beginning, I feel somewhat humbled. You are the people that know and can help guide to help us determine whether any of the ideas, hopefully some are, may be valuable in helping assure a successful future for Ukraine. That's it. Thank you very much for your time. And I managed to do it in under 10 minutes, I think.
Super. And
so that was an excellent opportunity to accidentally miss a slide. So yeah. Thank you very much for your time today. I really appreciate it, and bless you all. Thank you.
Super speech and your presentation. Thank you. And Ukraine has now PSD2 implementation in our law, but now we are working on the next PSD3 implementation, and as told about Ukrainian system DIA, Valentin Gvozdy, and all advocates also using this system. We have government in your pocket, in your phone, and we are now a very well developed system, open banking and open government system in Ukraine, but also cybersecurity and different dangers from cyber attacks. It's very important for national security of Ukraine, and I believe your experience and our communication and your international network can help us. So waiting for new project, new ideas, and maybe we can share your experience for Ukrainian academics and PhD students.
It would be a pleasure. Thank you. Academic collaborations would be very welcome. Thank you.
Thank you. Thank you very much. And our next speaker, I want to invite Dr. Dmytro Fedchishin. He's also advocate, Doctor of Law at the Parisian National University and honorary research fellow of School of Law, University of Aberdeen, Scotland. So also brilliant example, Ukrainian advocates, Ukrainian academics, and Scottish academic researcher. So Dmytro has a very interesting topic about digitalization and food security, because the sphere of expertise of Dmytro, it's agrarian law and land law. So it's very, very interesting example when digitalization, food security, and land law. So, Dmytro, welcome to your presentation. We are all waiting very well.
Yes. Hello, everyone. Thank you for the opportunity to participate in such an interesting event. Too much interesting information for me, but my report will be a bit different. Yes, about food security and about fisheries activities.
Sorry, you have an echo. Maybe
I don't know. Is it okay?
Sound. Sorry.
Maybe I'm too close. Can I make a demonstration? I have a little presentation. Yes. As already been told, I am a lawyer and a scientist in the sphere of land law and agricultural law. My report completely differs. Sorry, let's start. Completely differs from everything what has been told before, but at the same time, the issue is quite important. I want to talk about the problems connected with the ensuring food security in Ukraine, steps of digitalization of the sector of fisheries in Ukraine, and how it will affect Ukraine's world food security. Today, food security plays an important role in the development of any country, and Ukraine is not the exception in this context. On the contrary, before the outbreak of full-scale military aggression by the Russian Federation, Ukraine was one of the world's largest food exports, as you can see the total of world's amount of exports of wheat, 10%, 15% of corn, 50% of world's markets of sunflower oil, barley has been exported by Ukraine. And the country has been considered as one of the guarantors of global food security in the world. However, the hostilities have changed a lot. Today, large territories are mined or contaminated not only by artillery shells but also by waste from the use of military equipment and techniques. Shells have hit water bodies, killing life in them. Here are some statistics about the land destroying or pollutions. Also, the Kakhovka dam has been destroyed. As a result of this loss, losses to the fishing industry amounted almost 10 billion Ukrainian hryvnias. It's almost 40 million British pounds. For agriculture, this event possesses also significant risks.
Can I ask you about more for our interpreter should be have some time for translation for Ukraine.
Okay. For agriculture, this event possesses significant risks as reclamation processes in one of the most important agricultural regions, Kherson regions, were disrupted. Despite all these problems and obstacles, life goes on. Ukrainians fighting for their country, for freedom, for democratic values, and of course we believe we will win. Definitely we will win, no doubt. At the same time, we need to think about our future. Ukraine needs to restore its positions in global food market as a major player. and certain steps are already being taken to do so. They are related in particular to digitalization of economic sector that directly affects food security. One of these areas is the fishing industry, which provides fish not only to domestic consumers but also to foreign ones. The fishing industry is an extremely important sector of country's economy, which not only affects the economic development of the state, but also contributes to the well-being of the population and ensures food security of our country and its population. According to Article 1 of the law of Ukraine on fisheries, commercial fishing, and protection of aquatic bioresources, fishery activity means the activity of legal entities and individual entrepreneurs related to the study of aquatic bioresources, their protection, reproduction, special use, processing, and sale. Fisheries activities in Ukraine can be carried out in several ways. This is in the form of aquaculture and in the form of special use of aquatic bioresources. These are two different areas that need to be distinguished from each other. They even have different legal regulations. So let me say some about this difference. First, aquaculture. The legislation on aquaculture consists of the law of Ukraine on aquaculture, water code, land code, law on wildlife, and different resolutions of Cabinet of Ministers and other orders of state authorities. According to the current legislation of Ukraine, aquaculture is recognized as an agricultural activity of artificial breeding, maintenance, and cultivation of aquaculture facilities in fully or partly controlled conditions for the production of agricultural products. A fishery body for aquaculture purposes is provided for use on a lease basis to a legal entity or individual in accordance to the Water Code of Ukraine. In accordance with it, water bodies are provided for use under land lease agreement together with the body located on it. The right to lease a land plot under a water body extends to such a water body. In other words, in order to start an aquaculture activity, it is necessary to lease a land plot of the water fund. A person who has leased a water body has the right to grow any fish and use any fishing gear, any fishing means in order to catch it. In this case, a person just have to pay rent payments for the land plot of the water fund. The next activity, another activity, is special use of aquatic bioresources which is carried out by means of their extraction from the natural environment. Such special use of aquatic bioresources includes industrial commercial fishing, research fishing, or recreational fishing in public water bodies that exceed the established volumes of free fishing. Such activities are regulated by the law on fisheries, commercial, industrial fishing, and protection of aquatic bioresources, Water Code of Ukraine, law on wildlife, resolutions of Cabinet of Ministers, and orders of other state bodies. The special use of aquatic bioresources is carried out on the basis of permit. And finally, speaking about decentralization, Ukraine has made huge steps in order to provide digitalization of this sphere. Thus, on 22nd of December previous year, 2023, the Cabinet of Ministers of Ukraine adopted a resolution some issues of special use of aquatic bioresources, which introduced new approaches to obtaining the right to special use of aquatic bioresources. In particular, it provides for holding of auctions for the sale of the right to conclude contracts for the right to conduct fishing activities. We can call it fishing contract, and you can obtain this right through electronic bidding. The auction is organized by the State Agency of Ukraine for the Development of Land Reclamation, Fisheries and Food Programs. And this auction is taking place online, electronically, with the use of Prozoro system. The procedure of the auction is set in this resolution. Based on the results of the auction, the winner is entitled to enter into a fishing contract. Such a contract can be concluded in 20 days after the auction, and it can be also concluded in electronic form. After entering into a fishing contract, such an entity must also obtain a permit for the special use of aquatic bioresources, and this permit can also be obtained through can be obtained online remotely. So it's also one of the innovations. Another significant achievement of this in this sphere is that in 2023, last year, the Unified State Electronic Fisheries Management System, E-Ryba, E-Fish, was launched in Ukraine, and it should also improve the digitalization processes in this sector. The first tool available in this system is the declaration of the right to commercial fishing. During now only this possibility is available. During the pilot project, declarations can be submitted annually to the system. The services, there will be also several other services, but they still not introduced, but will be there soon. These services will be available online without having subjects of special use of aquatic bioresources shouldn't go to government bodies, offices, and fill out any paper applications. This will significantly speed up the service, remove an official from the process, and significantly reduce the burden on business, as the online services will automatically issue a permit or other documents within several days. As the creation of the Unified State Electronic Fisheries Management System will change the approach to market formation and interaction between the industry and government authorities. And as for the good results, recently there was a public report of the head of the State Agency of Fisheries, and according to it, there is information data that for the 2023, the catch of the aquatic bioresources in our country has increased by 13% and compared to the 2022. And it has reached the amount of 38,000 tons. Of course, comparing to 2021, it's twice, as a result, is twice lower. But now, in the current conditions of war, our state agency of fisheries doing everything, introducing such digitalization moments in order to improve our fisheries sector. All this will certainly have a positive impact on food security, both in Ukraine and in the world. Thank you for attention.
Thank you very much, Dmitry. One question for you, for your experience in Scottish and British law and Ukrainian law. What do we should use from British law in Ukraine, or maybe Ukraine have more positive experience experience in your sphere? Because as I know, they don't have system like Ukrainian, ye fish, ye riba, and maybe it's some innovation, maybe very interesting for our British colleagues.
I can tell about Ukrainian, of course, moments, because we have really good positions in order to develop our fisheries industry, because Ukraine has a lot of water resources, and our sphere is becoming more and more developed recently. Of course, taking into account the experience of countries all around, because previously the sphere, maybe 5-10 years ago, the sphere of legal regulation of the sphere has been very controversial, and now there are a lot of court proceedings in which prosecutors and other subjects of fisheries don't understand really what goes on in this sphere, and now we are trying to improve the regulation of the sphere, and introducing of all these changes have positively affected and will to the sphere, and we think will soon have a good results in it.
So I think maybe in future famous Scottish salmon will coach using Ukrainian Yeriba system.
Yes.
And our next speaker, and maybe a lot of our participants waiting for answer for question in chat about artificial intellect, about intellectual property for software generated by AI. Sergey Barbashin, president of European Young Bar Association and one of the top IT law advocates, and our colleagues from Ukraine. Welcome to your presentation.
Thank you, Alex, one more time. It's really a diversity of topics today, and we discuss such matter that's more provided, and the further topic is about IT. So I'm just struggling, just trying to think about previous presentation. So thank you for the time. I will share my screen to show some information in writing form also. So my second topic today is related to IT law. This is my primary practice area, and I would like to briefly introduce you challenges we may face as lawyers during identification of IP rights and transferring of IP rights. I'm not only president of the European Young Bar Association and Lawyers Association, but also practicing attorney in this sphere. I have my own law firm, and on my and our practice area are IP law, intellectual property, blockchain, etc. But some facts from my background. In the past, I was a professional computer gamer, and I took participation in the tournaments. And to be honest, I do like this sphere from like my childhood, and also finished some IT courses in the past. To be honest, I didn't enjoy coding, so be a programmer, but I decided to be close to this sphere. And I didn't regret about my decision that I'm a lawyer and work with these spheres. So challenges in IT we may face as lawyers. First of all, these objects are comprehensive. We may have many parties and different jurisdictions. Just a brief explanation. IT product is almost consists of intellectual property object. If we're talking about real estate or other types of property, we as lawyers take care about ownership certificates, registration, etc. But in IT law, this is not exception, and we should do so also to register a trademark, to receive patents, to receive copyright protection, and so on. I agree that IT objects are comprehensive, but I suggest to keep in mind that many IT components will be protected under copyrights. and would like to draw your attention into two crucial things. First of all, idea is not protected. You as lawyers, I know, should be aware of this moment, but sometimes we forget about that. Just imagine IT entrepreneur comes to us and asks to protect his idea. For example, he would like to protect applications that provide solution where to better register crypto platform, etc. The idea of this mobile application is not protected, but current mobile application, code, graphic images, etc. that's alive, this idea, and turned into force, can enjoy copyright protection. And second point, I would like to draw attention that there is the list of copyright objects are not exhaustive, and many of them in IT solutions may enjoy copyright protection. For example, on computer programs, games, graphic images, algorithms, databases, etc. Starting to work with IT, just let's have a look to a few examples. Website. It's a comprehensive IT object because it may consist from articles, images, codes, databases, etc. Mobile application may have similar approach. If you're talking about more larger objects such as games, it may have scripts, codes, structures, and others. And of course, different graphic images and animations. So my suggestion, starting to work with IT object, we should understand their parts, and we should split them into categories as lawyers to properly transfer IP rights. To enjoy copyright protection, this object should follow into two criteria at least: originality and tangible form. Let's consider these two moments in terms of codes and code protections, because the code is basically the basis of many IT components. I suggest to keep in mind following factors for IP protections. First, the code should be created by developer. I noticed that in the chat we have a question related to AI and similar questions, but for the time being, the many countries and the common approach that IT or copyright object should be created by individual to enjoy copyright protection. It should be original and should be in tangible form. This means that code should be in writing form or like in application or somewhere, not only in the mind. And we cannot protect taking open source part from like open codes, third parties, third program, etc. As an example, recently we had a request where we're supposed to clarify IP rights and components of the object. We discovered that IT developer used 15 different code and programs to create his own object. We started to clarify each code by license by license. I discovered that three of the codes three licenses of these codes have limits of the future usage. They prohibit commercial usage. In our situation, we excluded these codes from the object to avoid third-party IP rights violation. And how we can, as lawyers, describe these codes or how does it work? I suggest to keep in mind that code could be like a bridge that connects one software with another. And our primary task is to identify this bridge, working closely with IT developer, with their team. And to be honest, sometimes it's kind of difficult because we need to understand technical issues also. In our scenario, we have a special questionnaire to work with technical team. And normally we can ask them, please describe how does it work? Is it whole code yours? May we identify the code by small parts, or we should use it at all? And what is the subject or the specific heart of the code? By receiving such answers, we can understand: did they develop this code by the team, or they use different objects? If so, we need to clarify licenses. Also, if I would like to protect this code by registration, it's better to understand which parts we can disclose and which is better to keep hidden. For example, I always ask our clients, is it possible to identify your object by some small parts and to provide it for registration, but keep your parts of the code hidden? And it's always difficult to find a solution. But anyway, starting to work with such object task by task, we can receive answers and find a solution how to better protect this code. And similar approach we may use in IT spheres in terms of images, because we also can check licenses, who is the owner, form, etc. And as a conclusion, how to prevail? I suggest to work directly with a team, with technical team, because sometimes business owners don't understand the technical aspects. Identify each object which you may find in these IT solutions, and split third-party rights and current project IP rights. Is to how identify IP rights. First topic, first part of my presentation, and how to protect IP rights or maybe transfer that. Often we may find in the contracts paragraph like performer transfer all IP rights to the clients. This could be, but I suggest to have a larger explanation of the contract, at least to specify some parts of that. For example, to identify the rights despite the disclaimer in the law. Why should we do that? First, our law changes from time to time. Second, if you would like to show disagreement to third parties, let's say investors, lawyers from different jurisdictions, it's better to them to understand your contract, the clauses, and not to track your law. And if you have a unique using of this object, it's better to specify in the contract. So my suggestion is to have general conditions and identify the rights you transfer according to this agreement. Second, according to legislation of Ukraine and other countries, we have IP rights transferring by automatic way. But from time to time, it's useful to sign additional documents such as acts to identify these rights and confirm this IP rights transferring. Of course, we're trying to work with less bureaucracy, and to do that, we can sign this acts monthly during the termination of the project, or once we have a final result of the object. And last but not least important, of course, IT developer works or programmer will work by alone, and it's always difficult to understand this is his work or not. So I suggest to add guarantees to the contract that this person work directly and transfer all IP rights to our company. And as a conclusion, in this parts, while we have these contract clauses, also we may link our contracts with digital solutions like GitLab, DigitalOcean, and other sources. And by doing this, we should not add to our annexes to our contract like our code, our images, etc. We may easily track this information by such account. And how to sign such document? In our practice, we use electronic tools such as Adobe Sign and DocuSign and other solutions. From my perspective, it's really useful. And but I suggest to have in the contract this disclaimer, how you can sign the contracts, and it's better to indicate name of the programs to avoid problems in the court if you need to protect your party interest during the litigation procedure. Unfortunately, because of lack of the time, I cannot provide example of litigation procedures. Just some information in terms of AI. We have, for the time being, we have different regulation approach. For example, in Ukraine, we have AI regulation roadmap. In Europe, we have preventive approach by EU AI Act implementation. And if you're talking about Europe and the AI Act implementation, you may see the following timeline: that we have formal adaptation in April, probably we'll have publication in May, June, and after the Act may enter into force. Also, we have some provisions that this law will have like 1-2 years to implementation to the companies, and we as lawyers, I believe, might have extra work to adopt their policies, to prepare this policy to the website, and to help businesses to adapt their work. And do AI works have copyright protection? We also have different approach for the time being. For example, in United States and Ukraine, the creation of works requires significant human involvement. Generally, authors should be individual. I found that in UK, copyright protection of copyright generated works may be. And also in Ukraine, we have interesting objects like sui generis that work created by AI can enjoy copyright protection. This according to our Copyright Act, Article 33. And who will be the owner of these generated works? Also, we may have different approach, and I believe we can answer in the future for these questions. For the time being, I have two visions. First of all, if you use this AI tool as a tool only, for example, as a Photoshop, so we have our own object, we just moderate, make some edits, etc. User should be an owner of these results. But in case we use this AI tool at all, for example, we just set some small task, we don't take significant participation. In this scenario, probably AI owner, AI program owner will be owner of the results, or we need to double check agreements according of this AI tool. So as conclusion, as final conclusion, I suggest to understand parts of IT object to clarify them in the contracts and IT team contribution. Transfer IP rights, despite disclaimer in the law, according to the annexes and additional agreements, it will be easier to track in the future by third parties, investors, and so on. And of course, take care of AI. We are monitoring AI rules for the time being and expect in 1-2 years final legislation and, let's say, rules for this regulation. Thank you for your time, and I apologize that I have had 3 minutes more on my speech.
Well, thank you, Sergey. Very wonderful presentation. We all know what you well know, expert in this case. Thank you for your presentation speech. And our next speaker, I welcome Sergey Denisenko, cyber expert, court expert, expert in criminology and IT science with own presentation. So Sergey, welcome. Oh, sorry, somebody's microphone. It's about dangerous in the digital era. So, welcome. Sorry, Sergey.
Радий вітати всіх наших колег, всіх учасників даного заходу. Я вважаю, що даний захід є дуже важливим в розрізі співпраці з міжнародними нашими партнерами. Також в даному заході, я бачу, залучається багато фахівців по таким темам, які є найменш вивченими. І я вважаю, що даний захід є основою для того, щоб в подальшому продовжувати співпрацю, розвивати дану тематику. І взагалі в реаліях сьогодення це дуже важливо. Тема моєї доповіді, моєї розповіді – це боротьба з кіберзлочинністю в розрізі пошуку, фіксації, збору та збереження цифрових доказів, реалії сьогодення та перспективи найближчого майбутнього. Чому кіберзлочинність? Тому що в реаліях війни це дуже актуально, і це є тема, яка постійно звучить із телеканалів, звучить із трибун Верховної Ради, і взагалі вона дуже актуальна. Організація кібербезпеки як процесу є невід'ємною частиною механізму захисту інформаційної безпеки як держави, так і звичайних громадян. Враховуючи реалії сьогодення, все частіше стаються злочинні посягання на кібербезпеку, так звані, ми їх називаємо кіберзлочини. Основною загрозою таких діянь є те, що в результаті їх можливе порушення цілісності інформаційних процесів та втрата критично важливої інформації. А в нашому випадку це і втрата і військової інформації. Зіткнувшись з реаліями сьогодення, можна відслідкувати певні негативні тенденції, що виникають під час кіберінцидентів та кіберзлочинів. Всі ці тенденції я розповідаю з цієї практики, в якій я постійно працюю, вивчаючи ці інциденти і маю певні висновки і певні критерії їх оцінки. Організовуючи процес розслідування кіберзлочинів, необхідно в першу чергу керуватися чинним законодавством, яке регулює цей процес. Без законодавства ми нікуди не зможемо піти. Чому? Тому що це є ті грані, які обмежують нас в певних діяннях. І це також викликає певні загрози і ризики. Процес збору цифрових доказів в даному нашому законодавстві, саме в нашому законодавстві, він не до кінця вдосконалений, потребує подальшого опрацювання і вдосконалення. Так, зокрема, не дотримуються основні правила процесу щодо цифрових доказів після того, що після інцидентів і ці докази потім неможливо визнавати в процесуальному порядку як вже цифрові докази, і в даному випадку вони або знищуються, або пошкоджуються. Це виникає в процесі того, коли розслідуванням кіберзлочинів займається декілька правоохоронних органів, декілька державних установ, і передача, збір, фіксація відбувається не в повній мірі і втрачаються ці докази. Ну, наприклад, якщо брати цивільний сектор, бізнес, то ми стикалися з випадками, коли йшло шифрування системи, шифрування комп'ютерів, наприклад, в магазинах. IT-спеціалісти перестановлювали операційну систему, при цьому втрачалися ті докази стосовно механізму, способу, яким чином, хто це зробив і, в принципі, що призвело до цього інциденту. Таким чином, знищивши речові докази і створивши ситуацію, що правоохоронцям дуже важко було б довести стосовно тієї особи, яка це вчинила, і стосовно того, яким чином це було здійснено. Якщо підійти до процесу розслідування кіберзлочинів в цілому, то необхідно встановити типові етапи реагування на ці інциденти, враховуючи те, що вперше інциденти виявляють володільці тих цифрових активів, якими вони володіють. Ці етапи можна розділити на: перше – це зупинка самого інциденту в разі, якщо він продовжується, та ізолювання засобів атаки. Ну, це зрозуміло, якщо відбувається процес шифрування комп'ютера або відбувається процес копіювання вашої інформації, то тут повинні це призупинити. Це як перший етап і саме основний. Далі ті, хто виявляє ці кіберзлочини, він повинен провести ідентифікацію інциденту, класифікувати подію та оцінити ті наслідки, які настали або можуть настати. Під час даного етапу аналізується сам інцидент за встановленими параметрами. Перше – це обсяг, який залежить від кількості скомпрометованих інформаційних ресурсів. Ну, наприклад, це, якщо велика компанія, в неї є ресурс, це сервери, де зберігається інформація, робочі комп'ютери, веб-сайт і так далі. Тобто зрозуміти, на які ресурси було здійснено і який об'єм скомпрометованих цих ресурсів. Друге – можливі способи створення цього інциденту та методи, яким способом це було створено. Ну, наприклад, якщо це брати спосіб створення, то яким чином це відбулося? Це електронна пошта, це хтось вставив USB-накопичувач, це якийсь бекдор обладнання, або інші якісь там негаразди або бекдори в обладнанні. Друге, це яким методом це, наприклад, троянська програма, вірус і так далі, і так далі. Цих методів дуже багато. Ну і третє, що відбувається під час ідентифікації інциденту, це визначення його критичності. От від цього параметру вже залежить майбутнє цього інциденту, тобто чи буде особа або володілець, або хто кому-небудь, на кого був здійснений кібернапад, повідомляти правоохоронні органи. Тобто ми визначаємо, і в принципі визначається критичність, це не критичне, яке не призводить ні до яких наслідків, це там середньої критичне або там особливо критичне. Тобто це сам володівець цих ресурсів, сам визначає. Третій етап стосовно реагування, розслідування кіберзлочинів – це створення робочої групи, якщо це на підприємстві відбулося, або повідомлення правоохоронним органам про цей інцидент, про цей кіберзлочин. Після цього етапу розробляється план реагування, якщо це підприємство, і вираховується та стратегія, яка буде проводитися стосовно розслідування. Ну і що стосується п'ятого етапу, це ті технічні заходи, про які я більш детально хотів розповісти. Це перше – ідентифікація, класифікації подій, аналіз обладнання, тобто це проведення, так би мовити, інвентаризації того обладнання, на яке здійснено посягання, для того, щоб вже в подальшому розробляти механізми, якісь для того, щоб пошукати вже ті цифрові докази, які можуть бути там знаходитись. Друге – це збирання. Це пошук цифрових доказів на тому обладнанні, яке було встановлено, на якому вони можуть бути. Тобто пошук доказів цього інциденту, кіберзлочину. Третє – це здобуття, фіксація цифрових доказів інцидентів та їх однозначна ідентифікація. Для чого це робиться? Це для того, щоб чітко прив'язати доказ до об'єкта, вирахувати його, наприклад, контрольну суму МД5 або СХА, і в подальшому це доказ, ця інформація, ці дані будуть вже ідентифіковані і вже можуть виступати як доказ в процесі. Ну і третє – це збереження, копіювання цифрових доказів та документування процесу. Це розуміється те, що копіювати ті докази, які вже ідентифіковані, для того, щоб подальшим їх можна було фізично передати для подальшої роботи з ним або правоохоронні органи, або іншим спеціалісти, які вже будуть проводити більш детальний аналіз або проводити судову експертизу. Також хочу зазначити, що під час реагування на інцидент інформаційної безпеки або кіберзлочин всі технічні заходи хронологічно документуються у вигляді окремих документів чи протоколів. Чому? Тому що після цього, проаналізувавши ці записи, можна вже встановити, яким чином це відбулося, визначити цей процес і, відповідно, вже реагувати в напрямку пошуку особи, яка це скоїла. Ну і останній етап – це аналіз отриманих даних та передача результатів для правоохоронних органів. Тобто, якщо володілець інформації визначився, що цей інцидент є незначним, якщо наслідки відсутні і ці наслідки або їх можна швидко усунути, то він не передає до правоохоронців. Якщо наслідки тяжкі, то він вже передає до правоохоронних органів. Під час даного етапу остаточно встановлюється спосіб створення та методи самого інциденту, де зазначаються інструменти, якими вони були здійснені. Тобто це віруси, це віддалене проникнення, це якісь троянські програми або інші шкідливі програмні засоби. Також під час даного етапу вже формується певна доказова база, що може складатися і складається з документів, які документували даний процес, і самої цифрової інформації, яка вже зберігається на окремих носіях. Ну і в подальшому формуються висновки і вживаються певні заходи стосовно тих рішень щодо недопущення повторних кібератак або оновлення програмного забезпечення, оновлення обладнання або впровадження певних документів інформаційної безпеки, які регулюють ці процеси в будь-якій організації. Якщо детально розглянути і проаналізувати етап технічні заходи, встановлено основні критерії щодо нього, і ці критерії є такі от вразливі стосовно того, що відбувається наразі зараз, в принципі, в нашому житті. Один із цих критеріїв – це персонал, це фахівці. Відсутність відповідної теоретичної та практичної підготовки сильно впливає на результати цілісних здобутих цифрових доказів. Ну, тут зрозуміло. Інші критерії – це обладнання та програмне забезпечення, що використовують фахівці. Адже воно відіграє велику роль під час аналізу самих цифрових доказів. При цьому існує інша проблематика в самому обладнанні. В реалії нашого життя, в межах нашої країни дане обладнання та програмне забезпечення, воно дороговартісне, і не завжди фахівці або правоохоронні органи можуть купити ті комплекси, програмне забезпечення, які застосовуються саме для пошуку, фіксації, для збору цифрових доказів. Інша сторона в цьому – це те, що навчання фахівців на цьому обладнанні, воно теж є дороговартісне, і не кожна організація, тим паче державні установи, зможуть профінансувати своїх фахівців в тому, щоб вони навчилися нормально користуватися цим обладнанням. Також ми стикнулися з іншими проблемами стосовно придбання окремих комплексів. Ну, наприклад, експертний контроль деяких країн забороняє ввозити на територію України обладнання. Ну, наприклад, програмно-апаратний комплекс GRK компанії Магнет, його заборонено ввезення і використання на території України. Що стосується пошуку, фіксації, збору цифрових доказів, інколи стаються ситуації, що вони знаходяться на обладнанні, яке фізично розташоване за територією нашої держави. Там отримати фізичний доступ до нього наші фахівці не можуть. Участь фахівців чи правоохоронців тих держав, де розміщується обладнання, часто викликає сумнів, так як невідомо, яким чином вони фіксували та зберігали цифрові докази. Тобто основною проблемою процесу доказування в таких ситуаціях є те, що наш законодавець чітко визначає наявність доказів при матеріалах справи, але не завжди ці матеріали можна долучити до матеріалів. І тут вже постає питання стосовно достовірності тих чи інших фактів чи подій, які зафіксовані на віддаленому обладнанні, яке не є в розпорядженні і яке суд не може дослідити в цілому.
Сергію, я з вашої згоди трошки нагадаю вам ще хвилинку на закінчення, потім перейдемо до питань. У нас має бути перерва перед наступною сесією.
Да, тоді ускорююсь і обрізаю. Да? Стосовно того, які ще питання піднімаються під час вивчення даної тематики, це стандарти, які регулюють ці діяльність. Стандартів є багато. За основу в нашій країні звикли брати стандарти серії ISO і EC, але деякі організації використовують стандарти NIST американські, і вони теж добре себе зарекомендували. Ну, знову ж, є дуже велика проблематика в тому, що деяких стандартів, які є державні, як ДСТУ, в нашій країні немає фізично, їх купити неможливо в країні. Якщо купувати за кордоном, це там від $180, і не кожна державна установа може за кордоном купувати ці стандарти, які є в оригіналі на англійській мові. Що стосується перспектив на найближче майбутнє, то необхідно усвідомлювати ту ситуацію, що складається в суспільстві, враховуючи ті ризики, які постійно виникають. Тобто економічне протистояння Сполучених Штатів та Китаю, стрімкий розвиток кіберактивності таких країн, як Іран та Північна Корея, їх агресивний настрій, може спровокувати збільшення кіберзлочинів, а також видозміну їх механізму скоєння. Адже кіберзлочини можуть і вже відбувається за участю штучного інтелекту. Можу нагадати те, що деякі злочинці почали за допомогою штучного інтелекту створювати шкідливе програмне забезпечення. Ну і до основних висновків по даній темі, висновки рекомендації і завдань, які нас чекають на найближче майбутнє, це постійне навчання та постійний процес підвищення кваліфікації відповідних фахівців, які приймають безпосередню участь у пошуці, фіксації, збору цифрових доказів. Розробка, впровадження та підтримка документованої інформації стосовно реагування на кіберзлочини в рамках існуючих і державних стандартів. Постійне вдосконалення обладнання та оновлення програмного забезпечення. законодавче врегулювання процесу стосовно пошуку, фіксації, збору та збереження цифрових електронних доказів, розробка, оцінка та запровадження в експертному середовищі України новий механізм впровадження методів та методик. Адже наразі теж є великою проблемою, що більшість методик вони не актуалізовані, вони наші реалії не підходять, тому що вони 2010-11 років, а на дворі вже 2024, і вони вже можуть не підходити, а в багатьох випадках не підходять під ті об'єкти, під ті цифрові докази, які досліджуються в рамках проведення судових експертиз. Ну і саме основне, чим ми сьогодні займаємося, це постійний обмін досвідом між фахівцями з кібербезпеки провідних країн світу між собою. Це стисло, ну, говорити можна багато по даній тематиці.
Дякую дуже сильно. Одне питання є, ну, тут, я думаю, воно більше юридичне, чи є порушення адвокатської таємниці важким наслідком. Так, я думаю, що це є важким наслідком, тому що ну, ви судовий експерт. Питання кваліфікації і наслідків – то є юридичне питання. У нас є спеціальні статті в Кримінальному кодексі, які убезпечують гарантії діяльності адвокатів, і порушення їх є тяжкими. Сергію, дуже вдячний вам. Для наших слухачів у нас зараз буде перерва на півгодини. Через півгодини у нас починається третя сесія, вона академічна. У нас буде доктор Гілмор з Портсмутського університету розповідати нам про правове регулювання криптовалюти. Ось доктор Тетяна Гудіма розповість, як обходять санкції, що таке міксери. Ось, і я розповім, як запобігати законодавчими методами персонального і індивідуального банкрутства фізичних осіб, і які ризики у нас несе недотримання прав споживачів віртуальних послуг. Дякую.